The following presentation is brought to you by Rise to the Rescue, supporting Joe Glean, Prospective Delegate for Virginia's 44th House District.
My fellow Virginians, I come before you today to remind you that the regulatory mechanisms currently being imposed on us by the federal courts and by the politicians do not properly fulfill the established constitutional amendment process. As it stands, there exists only one valid amendatory procedure to date, and that is the one that was enacted by the state conventions in 1788 and that was set forth in Article 5 of the federal Constitution. What does this mean? It means that those in power are not following the law. It means that our moral sovereignty is under attack, our Constitution has been undermined, and our Republican form of government of, by, and for the people has essentially been destroyed. Case in point, our future generations of children and grandchildren who have been subjected to abortion not because of the existence of any particular constitutional mandate, but simply because those in power for the past 40 years have continued to go through the motions of pretending that such a mandate exists. Politicians on both sides act as though the statutes supporting abortion are lawful, citing the published opinion of the states in their enactment of state statutory law and the Supreme Court in its enactment of federal case law. However, neither of these two proposed regulatory mechanisms correctly fulfill the specified constitutional requirements, where it is very clearly stated that amendments to the federal Constitution may only be enacted by Congress, ratified by means of a two-thirds vote in both houses of Congress, or by a constitutional convention called for by two-thirds of the state legislatures. We need to stop pretending that only a politically trained lawyer possesses the ability to contend with such simple and straightforward matters of constitutional law. The Honorable Leroy R. Hassell, Sr., former Chief Justice of the Virginia Supreme Court, put it this way: "The best way that you can preserve your rights is to learn as much as you can about the law. You and I enjoy many freedoms that most people around the world do not enjoy. The best way that you can protect those freedoms is to become knowledgeable and to read, learn, and educate yourself." I would add that when we do so, we discover right off the bat that Virginia law has long made a point of affirming the fact of life in the womb and offering clarity on the subject of personhood. It will be instructive to note, for instance, that our use of the word person, as it is rendered in constitutional law, represents the intentional removal of any presupposition relating to class or condition. In Chapter 9 of his famous argument on the unconstitutionality of slavery, published in 1841, Dr. G. W. F. Mellon provided an abstract of the proceedings in the Convention of the State of Virginia on the adoption of the federal Constitution. Here he delivers a useful dose of perspective on the proposed articles of constitutional law. He notes, "There were, in all, 20 amendments proposed. A number of these amendments proposed by Virginia were, for the most part, adopted by the people of the United States and have become a part of the Constitution. We can perhaps tell what meaning was meant to be put on these amendments by the word or words stricken out, as sometimes a single word will give a peculiar significance to a sentence and entirely alter its import. And is there not an important word in the above resolutions which would give a peculiar meaning to them? And is not that word the word freeman? If that had remained in, the framers of the Constitution may have been said to have meant slavery should be continued. But as we shall see, they struck it out and substituted the word person without any qualifications. Consequently, every person, regardless of that person's class or condition, is, by our Constitution, under its protection." Interestingly, where the advocates of abortion contend that the word person implies the existence of some unstated and often random condition relating to the effectual attainment of personhood at the beginning of life, or the retention of personhood at the end of life, a determination that I suppose may only be made by those in power, Mr. Mellon argued that the word person very uniquely represents the deliberate removal of any such condition or qualification. We are informed that the Virginia delegates struck out the operative word, freeman, and substituted it with a word containing no particular qualification beyond the obvious precondition of being human. It may also be noted that the general affirmation of personhood has long existed within the established framework of Virginia statutory law, though the practical implications of its existence have long been neglected. As indicated by the choice of words that were selected in the legal codification of Virginia's earliest abortion statute, introduced by the Virginia General Assembly in 1846, it was acknowledged at first by prima facie evidence, but soon afterwards, in 1849, by general revision, that the unborn child was a person, a term that still to this day remains etched in the Virginia Code, Title 18.2, Chapter 4, Crimes Against the Person. The law was placed among the 9 sections dealing either with cases of murder or cases of attempted murder, Sections 1 through 9. The following particulars of this law deserve our close and careful attention. Number 1. Abortion was likened to murder and was considered an offense against the person. Number 2. The law only punished acts of abortion that were willful, deliberate, and premeditated. In a case of accidental death, as when an abortion might happen to occur during an effort to save the life of the mother, and where it could be shown that a good faith effort had been made to spare the life of her child, the offense was to be considered excusable. Number 3. The law recognized that there are constitutional limitations to the benefit of being free. Though the aspiring abortionist may have been free, as it were, he was certainly not free to take the life of another human being. This understanding is consistent with the constitutional concept of liberty, which may be succinctly defined as freedom bounded by justice. We must return to an understanding of justice that recognizes the equity of all persons before the law, and that seeks to render equal and exact justice to all. As it stands, there are many politicians who have made it their business to suppress the role of government in this regard, especially when the issue of abortion is involved. Their campaign literature is often riddled with some of the most dreadful proclamations of prejudice, where the peculiar demand is made that we take into account the very circumstance by which the lives of certain individuals are called into existence. This sort of diabolic reasoning should immediately trigger an alarm in our hearts and minds. The abortion people are quick to remind us, for instance, that some are conceived in fornication, incest, or assault. Others, they say, are the unwelcome result of an unplanned pregnancy. So long as we live in a world where we are faced with such tragic variables, and where there also exists the possibility of lifelong illness or some other debilitating handicap, they contend, the worth and dignity of human life, especially life in the womb, is relatively negligible. In probate law, the right to inheritance has sometimes been withheld or neglected on the basis of such circumstances. And in this respect, it's true that the law sometimes does not take notice of those who are ill-conceived or misbegotten. The right to life itself, however, has absolutely nothing to do with inheritance rights. The signers of the Declaration of Independence understood it instead to be an inalienable right, a right that could neither be given away nor taken away. When this right was first codified in the Constitution of the United States under the Bill of Rights in 1791, the Fifth Amendment, it was stated that no person shall be deprived of life without due process of law. The 14th Amendment, Section 1, passed in 1868, goes a step further, giving each state the power and also the obligation to defend and protect innocent human life. The Bible offers some principled insights on this subject as well, where the most hardened advocates of abortion suggest that the lives of those conceived in rape or incest ought to be considered the least equitable of all human life. The Scriptures candidly affirm that even those begotten in dire woe awake from the womb as each of us do, in joyful clarity. Like many of you, I share the confidence and conviction of President Ronald Reagan in embracing the Christian ethic of protecting the sanctity of innocent life, both inside and outside the womb. Despite the Supreme Court decision in Roe v. Wade in 1973, President Reagan repeatedly asserted and reaffirmed his belief that the states are obligated by the 14th Amendment to protect innocent life, a conscious repudiation of the political posturing he took in 1967 when he governed California. In 1983, on the 10th anniversary of that Supreme Court decision, President Reagan issued the following statement: "We cannot diminish the value of one category of human life, the unborn, without diminishing the value of all human life." He went on to remark, "The real question today is not when human life begins, but what is the value of human life?" The abortionist who reassembles the arms and legs of a tiny baby to make sure all its parts have been torn from its mother's body can hardly doubt whether it's a human being. The real question for him, and for all of us, is whether that tiny human life has a God-given right to be protected by the law, the same right we have. Regrettably, it was in 1970 that the Virginia General Assembly approved a comprehensive initiative designed to formally cast aside Virginia's obligation to protect the rights of the unborn, in direct violation of the 14th Amendment. It was on this occasion that our state legislators voted to lift abortion restrictions in conformity with the Model Penal Code, Section 207.11, tentative draft number 9 of 1959, comparable with the Model Penal Code Section 230.3, official draft of 1962, of the American Law Institute, which contained a collection of liberalized abortion statutes based primarily on the concept of quality control, the myth of overpopulation, and the government's eagerness to capitalize on a strange public fascination with eugenics-inspired theories about social improvement. The proposed legislation sought to condone abortion in practically any circumstance, to protect the mother's physical and mental health, to terminate pregnancies resulting from rape or incest, and to terminate pregnancies upon detection of any grave mental or physical defects in the child. For fear that we may someday join those self-loving elitists who pretend to have a say in the matter of deciding whether such classes or conditions of human life are truly up to snuff, here are some final words of insight from our past president that are certainly worth repeating. Every legislator, every doctor, and every citizen needs to recognize that the real issue is whether to affirm and protect the sanctity of all human life, or to embrace a social ethic where some human lives are valued and others are not. As a nation, we must choose between the sanctity of life ethic and the quality of life ethic. As for me, I share the confidence and conviction of Ronald Reagan in declaring the same answer that our founding generation gave to this question, the same answer that the good people of our nation have always given, and I trust that this careful review of our founding documents has served to make that answer abundantly clear. When we look back on the history of Virginia and its heritage, we see a continual glimmer of hope, even in its darkest hours. We know, for instance, that it was the input of good, godly, moral individuals such as George Mason and Patrick Henry that had the greatest influence on our National Bill of Rights, much to the astonishment and bewilderment of a slaveholding generation and a world that knew nothing of liberty and justice. We know that even in the days of slavery, when Virginia was lost in its own state of moral chaos, the Virginia General Assembly at least had enough common sense and decency to affirm the moral sovereignty of our posterity in the womb. We know that even though our legislators moved to disfranchise black voters in the early 1900s, refusing to recognize or accept the civil and political equity of all men before the law, our former governor, Virginia Governor Charles T. O'Farrell, had preceded these men, performing his public duties with the highest level of respect, working vigorously and tirelessly during his tenure in the late 19th century to stamp out the practice of lynching. And we know that even though Virginia Governor Linwood Holton made a mockery of both his religion and his political party by subjecting our posterity to the tragedy of abortion in 1970, God has raised up the remnant of this generation by his own enabling grace. He has raised up good people like you and me to deliver a message, and that message is one that will be delivered at the ballot box on Election Day 2011.